Good afternoon, and thank you for joining us for an MP webinar covering avoiding an OSHA audit, best practices, and legal advice for employers. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today's program, Kathryn Hatfield. Ms. Hatfield's practice focuses on representing private and public sector employers in all aspects of labor and employment law. Ms. Hatfield's expertise in employment law includes litigating state and federal cases on behalf of employers, including Title IX, the ADA, the ADEA, and the New Jersey law against discrimination, providing legal opinions and advice on personal, employment, and labor issues involving, but not limited to, Title IX, the ADA, the ADEA, OSHA compliance, the Fair Labor Standards Act, the National Labor Relations Act, the Davis-Bacon Act, the New Jersey law against discrimination, wage and hour, and the Prevailing Wage Act, and preparing personal handbooks and policies involving issues such as drug and alcohol testing, absenteeism, and the leave of absence. Ms. Hatfield lectures frequently on employment-related issues, including OSHA compliance, family and medical leave, workplace harassment, wage and hour compliance, effective hiring and retention, drafting employee handbooks, and workplace anti-discrimination laws. Hatfield Schwartz Law Group is a woman-owned law firm located in northern New Jersey with a practice-centered labor and employment law. Founded by Stephanie C. Schwartz and Kathryn V. Hatfield in 2020, the firm provides dedicated personal attention to each one of their valued clients. Hatfield Schwartz was created with the mission to focus on client issues and determine innovative solutions with an unparalleled level of quality. We develop proactive business solutions, assisting their clients with their legal needs. And for more information, including how to contact them, please visit www.hatfieldschwartzlaw.com. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending a recording of the webinar later today along with the slides. And with that, I'm going to hand the mic off to Kathryn.
Thank you, Katie. Welcome, everybody. Good afternoon. Today we are going to discuss OSHA and how to avoid audits and best practices under OSHA. So the presentation topics that we're going to discuss today is an overview of OSHA, employer responsibilities, inspections, noncompliance, posting, citations, how to investigate incidents, what happens during an investigation, the anti-retaliation provision of OSHA. We'll make some observations about what's happening today, and then at the end of the webinar, we will address any questions you may have. I will say that if we can't get to all of the questions, you can email Katie and she will get them to me and I will respond to them as quickly as I possibly can. So OSHA. In 1970, Congress created OSHA. At that point, more than 90 million Americans were spending their day on the job. And those workers were our most valuable resource. But until 1970, no uniform or comprehensive provisions existed for worker protection against workplace safety and health hazards. So in 1970, Congress considered annual figures such as the following to support the need for worker protection legislation. As of 1970, job-related accidents accounted for more than 14,000 worker deaths. Nearly 2.5 million workers were disabled on the job, and 10 times as many person days were lost from job-related disabilities as from strikes. The Occupational Safety and Health Act of 1970 was passed to prevent workers from being killed or seriously harmed at work. The law requires employers to provide their employees with working conditions that are free of known dangers. The act was created and it resides within the Department of Labor to do several things. First, it encourages employers and employees to reduce workplace hazards and to implement new or improve existing safety and health programs. It provides for research to develop innovative ways of dealing with occupational safety and health problems. It establishes a separate but dependent responsibilities and rights for employers and employees for the achievement of better safety and health conditions. It maintains a reporting and record-keeping system to monitor job-related injuries and illnesses. It establishes training programs to increase the number and competence of occupational safety and health personnel. It develops mandatory job safety and health standards and enforces them. And it provides for the development, analysis, evaluation, and approval of state occupational safety and health programs. While OSHA continuously reviews and redefines specific standards and practices for industries, its basic purpose remains constant. OSHA strives to implement its mandate fully and firmly with fairness to all. In all its procedures, from standards development through implementation and enforcement, OSHA guarantees employers and employees the right to be fully informed, to participate actively, and to appeal actions. States are either covered by the federal OSHA Act or an approved state plan, or a mixture of the two. For example, in New Jersey, private sector employees are covered by the federal OSHA Act, but there is also a state plan approved by OSHA for public employees. Other states like California only utilize an OSHA approved state plan for both public and private employees. On the other hand, Florida only uses federal OSHA. So this map of the United States identifies which states have an OSHA approved state plan for both public and private sector employees, a federal OSHA plan for private sector and most federal employees, and an OSHA approved state plan for public employees only, and a private sector employees are covered by federal OSHA. I know it sounds a little complicated, but depending upon where you are, identify which is your state, and that is helpful. Under the OSHA Act, an employer is any person engaged in a business affecting commerce who has employees, but does not include the United States or any state or public political subdivision of the state. As such, the OSHA Act applies to employers and employees in such varied fields as manufacturing, construction, longshoring, agriculture, law and medicine, charity and disaster relief, and organized labor and private education. One common myth is that OSHA can't inspect companies smaller than 10 employees, but that is not the case. OSHA covers most private sector employers and workers either through a federal OSHA plan or through an OSHA plan approved by the state. And in most cases, size is not an issue. OSHA provisions, as I said, OSHA provisions do not apply to state and local governments in their role as employers. The OSHA Act does provide that any state desiring to gain an OSHA approval for its private sector occupational safety and health program must also provide a program that covers state and local government workers. This program must be at least as effective as its program for private employees. State plans may also cover only public sector workers. Although OSHA covers most places of work, it does not cover all places of work. For example, because airports are overseen by the Federal Aviation Administration, they are not covered by OSHA. There are some nuances. Farms may be covered by OSHA unless it is a family-owned farm that only employs immediate family. Then they are not covered. If there are any questions about whether your employer or your industry is covered, feel free to ask away. So what are employer responsibilities? This is a quick overview. I'm sure many of you are familiar with the various labor and employment posters that are required to be maintained on a job site. OSHA is one of them. There's a specific OSHA poster that we will show in the next slide. Employers also have an obligation to train employees to make sure that they're familiar with safety issues that could arise in the workplace. Employers are required to maintain accurate record keeping. They're also required to provide appropriate protective equipment that is necessary for the employee to perform their work. And finally, they are required to establish a safety and health program. There is a general duty clause of the Act which provides that each employer shall furnish a place of employment which is free from recognized hazards that are causing or likely to cause death or serious physical injury to their employees. That general duty clause is paramount in OSHA's enforcement practices because it's always something that they can fall back on. This is the OSHA poster. All employers covered by OSHA are required to post this in their workplace in a place where it can be seen. Unlike other posters, which need to be replaced on an annual basis, OSHA does not have to be, this poster does not have to be replaced each year. Again, we said that employers are required to train employees. Training should include educating employees on how to interact with hazards in a working environment. For example, being given the proper protective wear, such as goggles and gloves, or being shown a training video before beginning a job and what to do if somebody gets, say, chemicals in their eyes. Employers are required to develop training programs. OSHA has a training institute that can provide training for different areas of industry. And the Education Center the training is provided by nonprofit organizations who are authorized by OSHA. Those nonprofit organizations are selected through a competitive process, and it is based upon their experience in training for OSHA-related industries. The Education Center offers courses and seminars on a variety of safety and health topics and supports OSHA's training mission through community outreach effort. Courses are offered in Spanish, and there are various youth initiatives. OTIs also provide trainings on hazard recognition and avoidance. There are also different training requirements for different occupational areas on the hazards and conditions that may come with those various types of job. The categories are general, maritime, construction, agricultural, and there's a federal employee program. It would be a lot to discuss all of the different types of training for each different occupational area covered by OSHA, but more information can be found in the training requirements for OSHA standards guide on OSHA's website. So when must OSHA be notified? OSHA must be notified in the event that there is a fatality or the hospitalization of 3 or more workers. Under those circumstances, OSHA needs to be notified within 8 hours of the occurrence. And if an individual employee is hospitalized or there's an amputation or a loss of an eye, then OSHA needs to be notified within 24 hours. OSHA, one of OSHA's requirements for employers is obviously record keeping. And employers of 11 or more employees must maintain records of occupational injuries and illnesses as they occur. The purposes of keeping records is to permit survey material to be compiled by OSHA to help define high hazard industries and to inform employees of the status of their employer's record. Employers in state plan states are required to keep the same records as employers in other states and must report accidents to the state agency responsible for safety and health program. Recordable injuries and illnesses are those that have resulted in death or those that require medical treatment beyond first aid, usually meaning a hospitalization. So records must be maintained on the worksite for at least 5 years. Employers are required to post a summary of injuries and illnesses recorded during the previous year. And the records that must be maintained are those that are recordable injuries and illnesses, those resulting in death or the medical treatment beyond first aid. Employers are required to provide personal protective equipment that employees need in order to perform their job. Most employers are required to provide them with any equipment that minimizes exposure to the hazards that exist in the workplace. PPE may include gloves, safety glasses, shoes, earplugs, hard hats, respirators, coveralls, vests, and full body suits, depending upon the nature of the industry. This PPE prevents contact with workplace hazards such as chemicals, radiation, and electrical hazards. And OSHA recommends implementing a PPE program that trains employees on how to wear and maintain PPE in order to address any workplace hazards. Most of us are familiar with PPE only because over the past 2 years, we have had PPE drilled into our brains simply because of the COVID pandemic. We will discuss COVID a little bit farther in the presentation, but this is providing personal protective equipment to employees is one of the employer's main requirements. We talked a little bit about establishing a safety and health program. There are safety and health consultants out there that can help employers establish and develop a safety health program that is personal to their work environment. Employers, I highly recommend employers doing this because the consultants will make sure that employers have the processes in place. They can help identify workplace hazards, and they can give advice on how to remain in compliance with OSHA standards. Consultants are a great preemptor for workplace audits. They don't penalize you or cite you for noncompliance. They help you avoid that. So OSHA inspections. There are 6 types of inspections that we will discuss. OSHA is authorized under the Act to conduct workplace inspections to enforce its standards. Every establishment covered by the Act is subject to inspection by OSHA compliance, safety, and health officers who are chosen for their knowledge and experience in the occupational safety and health field. Compliance officers are vigorously trained in OSHA standards and in recognition of safety and health standards. Similarly, states with their own occupational safety and health programs conduct inspections using qualified compliance safety and health officers. Under the OSHA Act, upon presenting appropriate credentials to the owner or operator or agent in charge of an establishment, an OSHA compliance officer is authorized to enter without delay and at reasonable times any factory, plant, establishment, construction site, or other areas, workplace, or environment where work is performed by an employee. They are authorized to inspect and investigate during regular working hours and at other reasonable times and within reasonable limits and in a reasonable manner, any such place of employment and all pertinent conditions, structures, machines, apparatus, devices, equipment, and materials contained on the worksite, and to question privately any employer, owner, operator, or agent or employee. They have extreme authority in order to ensure that their standards are being met. So the types of inspections that they will conduct are imminent danger inspections, which are hazards that could cause death or serious harm. Those imminent dangers must be corrected immediately, or the employees need to be removed from the area. The next inspection is a severe injury or illness. If a report is made that somebody has sustained a severe injury, OSHA will come in. The third type is with employee complaints. Employees have the right to a safe and healthy work environment, and they have the ability to file confidential complaints, which will trigger an inspection fairly quickly. They also can conduct an inspection if they receive a referral of hazards from an outside source. For example, it doesn't come through a confidential complaint filed by an employee, but perhaps there's some other type of a whistleblower, somebody who has come onto the premises and noticed something highly dangerous and has reported it to OSHA. The fifth type of inspection are targeted inspections. Those are in high hazard workplaces that have previously experienced high rates of injuries or illness. Under those circumstances, OSHA will come in and do an inspection. And the last type is a follow-up inspection, which is in the event that there was an inspection prior to based on one of these five types, there will be a follow-up inspection to ensure that any violations have been satisfied. So what happens with employer non-compliance? There are citations and fines that OSHA can issue for serious violations or serious hazards. Within 6 months of the violation, OSHA will issue a citation and a proposed penalty. Citation should describe the violation, the proposed penalty, and the deadline for correcting the hazards. The violations are categorized as serious, willful, other than serious, de minimis, failure to abate, and repeated. OSHA's goal, however, is to maintain safety and correct standards. The types of violations, as I said, an other than serious violation is a violation that has a direct relationship to job safety and health, but probably would not cause death or serious physical harm. A proposed penalty of up to $7,000 for each violation is discretionary. A penalty for an other than serious violation may be adjusted downward by as much as 95%, depending upon the employer's good faith, which is demonstrated by his efforts to comply with the act, history of previous violations, the size of the business, and when the adjusted penalty amounts to less than $100, no penalty is proposed. A willful violation is a violation that the employer knowingly commits or commits with plain indifference to the law. The employer either knows that what he or she is doing constitutes a violation or is aware that a hazardous condition existed and made no reasonable effort to eliminate it. An example of that might be in a meatpacking plant where there are required to be covers on saws, and the employer knows that some of the saws do not contain covers and allows that condition to exist. Penalties of up to $70,000 may be proposed for each willful violation, with a minimum penalty of $5,000 for each violation. A proposed penalty for a willful violation may be adjusted downward depending upon the size of the business and its history of previous violations. However, usually no credit is given for good faith. If an employer is convicted of a willful violation of a standard that has resulted in the death of an employee, the offense is punishable by a court-imposed fine or by imprisonment for up to 6 months or both. A fine of up to $250,000 for an individual or $500,000 for a corporation may be imposed for a criminal conviction. A repeated violation is a violation of any standard, regulation, rule, or order where upon reinspection, a substantially similar violation is found. Repeated violations can bring a fine of up to $70,000 for each such violation. To be the basis of a repeated citation, the original citation must be final. A citation under contest may not serve as the basis for a subsequent repeated citation. A serious violation is one in which there is substantial probability that death or serious physical harm could result, and that the employer knew or should have known of the hazard. A mandatory penalty of up to $7,000 for each violation is proposed. A penalty for a serious violation may be adjusted downward based on the employer's good faith, history of previous violations, the gravity of the alleged violation, and the size of the business. Failure to abate a prior violation may bring a civil penalty of up to $7,000 for each day the violation continues beyond the prescribed abatement date. Additional violations for which citations and proposed penalties may be issued upon conviction include falsifying records, reports of or applications can bring a fine of $10,000 or up to 6 months in jail, or both. Violations for posting requirements can bring a civil penalty of up to $7,000. Assaulting a compliance officer or otherwise resisting, opposing, intimidating, or interfering with a compliance officer while they are engaged in the performance of their duties is a criminal offense subject to a fine of not more than $5,000 and imprisonment for not more than 3 years. Finally, de minimis violations are violations of standards which have no direct or immediate relationship to safety or health. Whenever de minimis conditions are found during an inspection, they are documented in the same way as any other violation, but are not included on the citation. When a citation is issued, an employer can have an informal conference with the OSHA officer to discuss the inspection, citation, and any relevant information. At this time, it is possible for the employer and OSHA to work out a settlement agreement and figure out how best to eliminate the hazard. As I said before, OSHA cares about safety and correcting hazards, not fining businesses just for the sake of fining businesses. If an employer receives a citation, it must be posted where employees can see it. It's important for employers to know that the more frequently cited violations, so they can make sure that they are not violating the same regulations in their workforce. If they are, they should promptly correct them to avoid getting a citation or being reported to OSHA by an employee. The top 10 cited violations in 2021 included fall protection violation, meaning that there's no safety equipment for the employer and the employee to avoid any falls. Respiratory protection violation, meaning that employees are not being required to wear masks or respirators in areas where they are required to. Ladders violation, hazard communication violation, meaning that hazards are not identified in the workplace. Scaffolding violations, fall protection training violation, meaning that you haven't trained your employees in how to avoid falls. Control of hazardous energy violation, eye and face protection violation, powered industrial truck violation, machinery and machine guarding violation. So those are the most frequently cited in 2021. Incident investigations take place when there is a fatality, injury, illness, or other type of close call in the workplace. The purpose of the investigation is to identify the hazard and take corrective actions. OSHA has recognized that people often want to blame one another and blame incidents on carelessness, but OSHA believes that all issues have a root cause that is more than carelessness. Although it is typical for a supervisor to conduct the investigation, OSHA recommends managers and employees work together because of their varied knowledge, understanding, and unique perspectives that may bring to investigating workplace incidents. Figure out why an issue exists and why it was not previously addressed. For example, if someone working in an office trips down the stairs and breaks their arm, it may be easy to say they were not paying attention while they were walking. But upon investigation, maybe it becomes evident that there is a lift in the wood right by the top of the steps. If the lift had been addressed sooner, the employee may not have tripped. Once the lift is addressed, the same thing should not happen in the future. Anti-retaliation. This is a very significant provision in OSHA's Act. And this anti-retaliation exists in most labor and employment statutes. Employees have a right to seek a safe and healthy environment on the job without fear of punishment. That right is spelled out in Section 11C of the Act. The law says employers shall not punish or discriminate against workers for exercising rights such as complaining to an employer, union, OSHA, or any other government agency about job safety and health hazards. It includes the ability to file safety or health grievances. It allows employees to participate on a workplace safe and healthy committee or in union activities concerning job safety and health. It also allows them to participate in OSHA inspections, conferences, hearings, or other OSHA-related activities. An employee exercising his or her OSHA rights cannot be discriminated against by an employer in any way, such as through fining, demotion, taking away seniority, or other earned benefits, transferring the worker to an undesirable job or shift, or threatening or harassing the worker. If an employee believes that they have been retaliated against for blowing the whistle, they must file the complaint with OSHA within 30 days of the retaliatory event. Now, while this is a very short period of time for reporting, note that your state or whatever jurisdiction your employer is located in may also have a separate whistleblower act. For example, in New Jersey, where I reside, we have the Conscientious Employee Protection Act, which permits an employee to file a complaint, a lawsuit for up to a year. And that allows employees to have a greater period of time to report retaliation. So you should just be mindful of that. So we all know OSHA from COVID. I think that's where most employers became familiar with OSHA unless they are covered by one of OSHA's standards. OSHA does not have a specific standard for dealing with exposure to COVID or any infectious diseases or pandemics. The relevant obligations come from that general duty clause that we talked about earlier that requires employers to provide their employees with workplaces that are free from recognized hazards that are causing or are likely to cause death or serious physical harm. In general, an employer must take reasonable steps to abate or prevent known hazards. Both the hazard and the steps to address it must be known. And exposure to COVID meets those requirements. So what do employers need to do? OSHA has identified 4 categories of risk to describe the workplace. One is very high, which are jobs with a high potential for exposure to known or suspected sources of COVID during specific medical, postmortem, or laboratory procedures such as healthcare or morgue workers handling specimens from patients or bodies of persons known to have COVID. The next is a high risk workplace. Those are jobs with a high potential for exposure to known or suspected sources of COVID, such as healthcare delivery and support, medical transport, who are exposed to known or suspected COVID-19 patients. Then there's medium risk workplaces. Those are jobs that require frequent or close contact with people who may be infected, but who are not known or suspected patients, such as those who may have contact with the general public. These types of workplaces are schools, high population density work environments, and some high retail settings. They include individuals returning from locations with widespread COVID-19 transmission. Once the level of risk has been identified, like other hazards, OSHA expects employers to work through the hierarchy of controls in determining the best approach to protecting employees. The different categories in determining the best approach to protecting employees include eliminating the hazard, engineering controls, administrative controls, safe work practices, and personal protective equipment such as gowns, gloves, face shields, and respirators. What kind of controls and which controls are appropriate are determined based on the category of risk in the workplace that employees are subjected to. The most common ones that we see that OSHA has emphasized are facilitating vaccinations, staying home if symptomatic, physical distancing, face covering, cleaning and disinfection, and then, of course, reporting COVID cases and death. OSHA has said that incidents of employees contracting COVID are recordable illnesses only under the following criteria. The case is confirmed as a COVID illness, the employee's exposure is work-related, and the case involves one or more of the general recording criteria, which is fatality or more than 30 people being hospitalized or hospitalization of one individual. Again, seasonal flu is not regulated, but OSHA has advisory guidance on it. Again, it is getting the flu vaccine, promoting hygiene, keeping people who are sick out of the workplace, and keeping the workplace clean. As we talked about before, OSHA's general duty clause really is the one that governs what employers must do in their workplace to avoid any workplace incidents. Workplace violence, there is no standard. OSHA has not developed a standard for that, but again, it is covered by the general duty clause. The top occupations with workplace violence include healthcare, social services, late night retailers, taxi services, and correctional facilities. These are the types of workplace violence that OSHA addresses, and only when it's criminal or a customer, client, and patient. They don't cover coworker, workplace violence, or personal violence. So what are employer best practices? Employer best practices require employers to provide a workplace free from recognized hazards that could cause or is likely to cause harm. Employers must be familiar with mandatory OSHA standards that are applicable to your industry. They must inform employees about those OSHA standards and workplace prevention measures. They must examine workplace conditions to make sure they conform with applicable standards. They must minimize or reduce hazards. They have to provide employees with safe tools and equipment and maintain that equipment. That's essential, is maintaining that equipment. They must warn employees of potential hazards. They need to provide training to employees on how to use personal protective equipment, how to use the tools that they need to use in their job. They must report any fatal accidents or hospitalizations within the appropriate time frame, and they must keep all required records. Obviously, they need to post the OSHA poster, and they need to provide employees with any requested information they may have. They must also cooperate with the OSHA compliance officer when the compliance officer comes in for any inspection. They may not discriminate or retaliate against employees for reporting complaints, and they need to post the OSHA citations, and they need to abate any citations or any hazards that are cited. Employees have a role in ensuring that the workplace is free from hazards as well. While OSHA does not cite employees for violations, they are required to comply with all OSHA standards, rules, and regulations. Employees have the right to seek a healthy work environment, but they are integral in ensuring that as well. They need to read the OSHA poster on the job site. They should comply with all OSHA standards. They need to follow the employer's safety and health rules and wear or use prescribed protective equipment. They need to ensure that they are trained on that equipment. They need to report hazardous conditions to supervisors immediately. And they need to cooperate with the OSHA compliance officer in their inspections. They need to exercise their rights under the act in a responsible manner and not exacerbate any situations. When the OSHA administrator determines that an employee has filed a complaint and it has merit, the administrator, the Secretary of Labor, will issue an order requiring abatement of the violation, and if the employee has been terminated, reinstatement with back pay and related compensation, payment of compensatory damages, payment of the employee's expenses in bringing the complaint, and either the employee or the employer may object to the Department of Labor's findings. If no objection is filed within 30 days, the finding and order become final. If a timely filed objection is made, however, the objecting party is entitled to a hearing on the objection before an administrative law judge of the Department of Labor. Within 120 days of the hearing, the Secretary will issue a final order. A party aggrieved by the final order may seek judicial review in a court of appeals within 60 days of that final order. It's important to note that these timeframes have been relaxed over the past 2 years, given the pandemic. And these, the 60 days and 120 days have not been followed necessarily. If the employer has in the past knowingly allowed an employee to do something such as leaving work early, he or she may be violating the law by punishing the employee for doing the same thing following a protest of hazardous conditions. If the employer knows that a number of workers are doing the same thing wrong, he or she cannot legally single out for punishment the worker who has taken part in safety and health activities. Workers believing that they have been punished for exercising safety and health rights must contact the nearest OSHA office within 30 days of the time they learn of the alleged discrimination. A union representative can file the complaint for the worker, and the worker does not have to complete any forms. An OSHA staff member will complete the forms with input from the worker. OSHA will investigate when a complaint is filed, and if an employee has been illegally punished for exercising safety and health rights, OSHA will ask the employer to restore that worker's job earning and benefits. If necessary, and if it can prove discrimination, OSHA can take the employer to court. In such cases, the worker does not have to pay any legal fees. If a state agency has an OSHA-approved state program, employees may file their complaint with either federal OSHA or a state agency under its laws. But as I said before, you need to be mindful of the fact that your state may have a separate Whistleblower Act that allows for a longer period of time for making claims of discrimination or retaliation. Okay, so now we will go to questions and answers. All right. Okay, so the first question I have is, for auto mechanics in Maryland, where would we find the regulations regarding loan work? You know, Wendy, that's a very good question. I will find that out and I will get back to you through Katie, because I'm not really sure. I'd have to go back to the very first couple of slides to see whether Maryland is a federal OSHA state or has their own state plan. But I would suggest starting at the state's Department of Labor, or you can get on OSHA's website. OSHA's website is extremely comprehensive, and you should be able to find information about Maryland on that website. The next question is, will we receive a copy of the slides? And yes, you will receive copies of the slides this afternoon. Okay. So one of the questions that I have is what kind of requirements should an employer follow when starting a business? So under the provisions of the Act, as I said, employers have to comply with the standards that OSHA has issued. So if you are starting a construction company, you can get on OSHA's website and download a copy of that standard policy. I also would recommend that employers create a safety and health policy when starting their business. And that policy should lay out all of the protections that employees are entitled to, as well as a non-retaliation provision. And another question, does OSHA offer free help for my business to comply with regulations? And the answer to that is yes. As we said before, OSHA's on-site consultation program offers free and confidential safety and occupational health advice to small and medium businesses in all states. They do give priority to high hazard work sites. The consultation program is completely separate from the OSHA inspection effort, and employers can find out about potential hazards at their workplace and improve programs that are already in place, and even qualify for a 1-year exemption from routine OSHA inspections. No citations or penalties are issued, and the employer's only obligation is to correct serious job safety and health hazards. In addition, OSHA's area offices provide advice, education, and assistance to businesses, particularly small employers, trade associations, local labor affiliates, and other stakeholders who request help with occupational safety and health issues. OSHA works with professional organizations, unions, and community groups concerning issues of safety and health in the workplace. As I said before, OSHA standards, there are many OSHA standards that require the employers to train employees to ensure that they have the required skill and knowledge to safely do their job. Next question is, am I required to prepare and maintain record-keeping records? And as I said before, employers with more than 10 employees and whose establishments are not classified as a partially exempt industry must record work-related injuries and illnesses using OSHA's required forms. Partially exempt industries include establishments in specific low-hazard retail, service, finance, insurance, or real estate industries, and some of them are also listed on the OSHA website. Employers who are required to keep record-keeping forms must post those forms and the summary of work-related injuries and illnesses in their workplace every year. Current and former employees or their representatives have the right to access injury and illness records, and employers must give the requester a copy of the relevant record by the next business day. Next question, are safety data sheets required for all cleaning products that are used by our employees? That is a very good question, and the answer is no, not all cleaning products are required to have safety data sheets. I can provide you offline with a copy of the cleaning products that are required to have the safety data sheets. And I will there's a series of questions by one participant regarding those safety data sheets, and I will get you that information offline. There's a question about working for an airline that is regulated by the FAA under a 135 operation, charter operation. We operate out of FBO locations where private and chartered aircraft fly in. Are we covered under OSHA? Again, I'd have to look at specifically that situation, and I can get back to you once I have the specifics of that type of an operation. So those are, let's see. Okay, yep. Other people would like the safety data sheets for cleaning products. What I will do is I will provide that to Katie, and she can distribute it to all of the participants online so that everybody has it. Okay. Yep, everybody seems to have a lot of questions about the safety products or the safety data sheets for cleaning products. And as I said, I will get that to Katie this afternoon so that she can distribute it. Okay, that's about all I have. If there aren't any other questions, I will turn it back over to Katie, and I look forward to speaking with you all again soon.
Thank you, Kathryn. Lots of valuable information on OSHA audits. Any questions that were not able to be answered, we will reach out via email. The NPHR team is here to help guide your organization on any HR compliance issues. If you would like to learn more about how we can assist your organization, please visit our website to set up a short 15-minute call. Be sure to join us next week on the same day and time for our webinar on avoiding an FMLA key steps to ensure compliance and mitigation risk of DOL audits. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar with the presentation slides this afternoon. Thanks for joining us and have a terrific day.